All right, in this video, we've got David Pearce back on with us, UK attorney, and we're going to go into some of the subjects like the Copa v. Wright case and the judgment, the Arthur Van Pelt versus nChain intellectual property actions that he's involved in, and then also a potential debate with nChain regarding intellectual property, cases or actions, and how the patents may apply or may not apply, and some of the cold swim that he's doing. So this is Gavin Mehl, man. Good to see you, David. How you doing?
I'm doing great. My hands are a little bit cold still, but I'm
It
fine.
sounds like you just got out of a cold plunge right now. So is
Yeah, well, I was in a rush. I tried to go as fast as I can, managed 4 laps around the lake, and then rushed back, got fish and chips, and a shower, and now I'm here.
yeah, that seems like that cold plunge. I mean, how do you feel after going in that cold water? Feel exhilarated, or what is it like?
Yeah. I mean, it's not real cold at the moment. It is 14, 15 Celsius. It's not cold. I've gone in a lot cold. You feel quite different when it's 3 or 4 Celsius. But yeah, the depths of winter.
Yeah. Yeah, I had I'll post one of the videos I did regarding the cold plunge in a couple years back here in this card if anybody wants to check it out. So it's definitely it's something that fun to get involved in, very, very exciting.
Yeah.
So
I,
well,
I would just say under supervision. If you're going to go out in open water, do it under supervision. Don't just jump in. It's dangerous.
oh yeah. Oh yeah. I remember one of the first times I jumped into the San Francisco Bay. I actually did a film on it, and I almost died. I just jumped right in and swam right right out about 50
Okay,
yards, and that was the stupidest thing you could do because you
not
start
not
panicking.
advisable.
It was a panic. I was unprepared for that. So
Yeah.
yeah, I have a video on that too. I'll post it. So, all right, David. Yeah, let's talk first about this. Just I want to get your insight on the judgment. I know you weren't obviously one of the attorneys in the case, but just your perspective that Justice Miller had shared, and maybe you could give a little background. I know that you had dinner with the court more recently, or and so how'd that go?
No, I didn't have dinner. I
Oh, it
just
wasn't dinner.
it was
Okay.
I did have dinner with Justice Miller last year. When I was I think I mentioned it last time. I was at a Union IP event. It's a pan-European IP group that I'm involved in. So he was on one. He was one of the judges on the panel that we got for this patent seminar. Um, and we always have the dinner the night before. So I met him there first time, and just sussed him out, as it were. We deliberately didn't talk about Craig Wright because he told us that he had these 4 cases coming up that had just been assigned to him. I think only a few weeks before that. So yeah, we avoided speaking about Craig Wright, but we did talk about Bitcoin. And then
Okay.
I was at a SEPA event. SEPA is the Chartered Institute of Patent Attorneys in the UK, and they hold events mostly in London. And they had a panel of 6 judges, including James Miller, Colin Burse, and Richard Arnold from the Court of Appeal, who did the appeal case on the I forget which one it was, the one that went to the Court of Appeal on the copyright issue last year. That was Colin Burse and Richard Arnold, and one other I can't remember. And then three other judges. So that was an interesting panel event. And before the and it was a room full of patent attorneys, so it was all geek fest effectively,
So
talking about
did you talk
patents.
to Justice Miller at all?
Well, he came up to me before the
He
before the
remembered
panel.
you. So what'd he
He
say?
remembered me, which was nice. And then I started blathering on about this book I've just read, that one, 24.
Oh,
um, and mentioned that it's all about Bitcoin, and it's a basically magical realism novel about Bitcoin that's sort of a bit Salman Rushdie-ish, and it involves these 24 words that turn out to be a seed phrase for Bitcoin. And surprisingly to me, he wasn't aware of deterministic wallets. So I started saying, hierarchical deterministic wallets, you can have a 24 words, and then that will determine all your private keys and public keys. You can have a billion private keys and public keys. determined by just 12 or 24 words. And he was interested in that, and he actually mentioned, "Oh, I'm surprised Craig Wright didn't bring that up in the case." But I said, "Well, it wasn't something that was relevant, and it came after I think about 2 or 3 years after Bitcoin was first released. So it's one of those things that everyone knows about, but wasn't actually there at the outset."
So did he
And
tell you, did he say anything else about the case?
um, well, no, that just to finish that point, what I found interesting, and I sort of knew already anyway, um, but what was interesting is that he didn't know what, to all of us who know about Bitcoin, is a sort of fundamental thing about Bitcoin. You have a seed phrase. He didn't know about that, and I thought, okay, so he, all he's learned about Bitcoin has been from what has been presented to him by the two parties, nothing else. And if you remember at the beginning of the trial, he made a point. The very first thing he said was, "People have sent me a load of books, and I've not read any of them because I'm only taking in what is being presented to me by the parties." And that's absolutely true. That's all he's been based on his judgment on. So nothing outside of what he's been given.
Sounds like he didn't do a bunch of independent research and all that. So
Definitely not, because I have seen people commenting on that.
I think
Oh,
we talked about that last time that we were wondering if he'd done a bunch of research, by some
yeah,
of the other
but
guests I had.
absolutely not. Otherwise, he'd know about hierarchical deterministic wallets, because it's one of those things that one of the first things you know when you're digging into the details of Bitcoin or any other cryptocurrency. They all use, as far as I know, they all use the seed phrase that you can determine all your keys with, because it's a very useful thing to have.
So it
But anyway,
sounds like he didn't bring up much else about the case.
well, I did say I said I did mention on Twitter that I was going to see him, and jokingly suggested if anyone wanted me to ask him anything. I thought, well,
Yeah.
I know people want me to ask him. And Adam Back said, "Can you ask him when the judgment is coming out?"
Yeah.
I thought, okay. So I just said to him, I thought I didn't expect an answer, but I just said, Adam Back would like to know when the judgment's coming out. He asked me, and he looked surprised, as if, Adam Back would ask me why. And he said, "Well, I'm aiming for the 9th of May," which turned out not to be true. But it came, what was it, 10 days after that? So
Yeah.
it was,
Shortly
by
thereafter.
that point, it was pretty much the judgment had been completed, bar a few dotting I's, crossing T's, I guess. And he looked pretty pleased about it. And then it was only a matter of a week or two after that that it came out.
So take us inside the judgment. What is your interpretation of it?
Um, well, it's just confirmation of what I was saying last time. I think the last time we spoke, we were halfway through the trial, and we had different views of it. You were saying, and I'd seen some of the videos you'd posted before, where you were saying, Craig won this point, and Copa might have won that point, and Craig did very well on this, and I didn't agree with that at all. My view, and I remember saying, if you wanted to put a score on it, it was 100-0 to Copa, after the first week, which I think is when we spoke round about then.
Seems
And
like you were right.
and from the judgment, I'm sorry, but I was absolutely bang on.
Yeah.
I was
Yeah.
right. Craig Wright, I can't see in the judgment Craig Wright scored any points whatsoever. It's such a I've never seen such a damning judgment of anyone or anything. Um, and it just kind of underscores what I would say, on the Bitcoin, maybe a Bitcoin maxi side, have been saying for years, that this guy is a liar and a fraud, and it's there in the judgment. He is a liar and a fraud. Let me just give you a quote, so I'm not just using my words. It is clear that paragraph 926. It is clear that Dr. Wright engaged in the deliberate production of false documents to support false claims and use the courts as a vehicle for fraud. Okay, so I can safely say now, without fear of being sued, he's a liar and a fraud.
Oh, that seems to be what the court said. So, you know, it's
Uh,
definitely yeah.
and the forging, there's no point going into any of the details, but paragraph 926, 925, all the evidence points inexorably to the fact that all the documents which Mr. Madden, we know Patrick Madden, found to be, quote, inauthentic, were forged by Dr. Wright. So all the 40 test documents that Copa were allowed to submit as possible forgeries, Justice Mehl said, yep. And in the appendix with all the 40 things, he says, and that the best bit is paragraph 2. It just says, to avoid setting out essentially the same conclusions 40 times, I can state at the outset that I find each of the allegations of forgery proved. Okay, that's 40-0 to Copa on that one.
And and
And then the final and one
yeah.
thing, there's no point reading loads and loads of quotes, but the one thing that I was saying earlier, I can't remember where, but on Twitter somewhere, be able to find it, is that I thought one of the key aspects of the case is going to be the judge's assessment of the witnesses, which is really important on the first instance at the High Court, because that's the sort of thing that doesn't get overturned on appeal. It's really important in terms of the findings of fact and the assessment of the witnesses. It's the one chance you get for submitting witness statements and being on the stand. You don't get to be on the stand again on the appeal. It's not a rehearing. So the assessment of Dr. Wright, sorry, judge calls him Dr. Wright, I don't call him Dr. Wright. The assessment of Craig Wright by Justice Miller is key to the judgment, not just the forgeries. But I was thinking it's going to be he'll find him an unreliable witness, which is the sort of terminology that you see in assessments of witnesses. And I was looking for that particular phrase, and he says, paragraph 915, for anyone who's interested, I have found Dr. Wright to be a thoroughly unreliable witness who was engaged in forgery on a grand scale and in his attempt to sustain his case has lied extensively. So that's about as damning as you can get. This guy cannot be trusted. His testimony cannot be taken seriously. You can't rely on it at all.
Let me ask you, let me just give you the two grounds that I saw that could be appealable, and I want to get your feedback
Go on.
on them, okay?
Yeah, definitely interested.
All
I
right.
saw you
Yeah.
allude to that, but
I
you didn't
want to
what they
hear
were.
it's
Go on.
yeah, I want
Go
to
on.
hear what you have to say. So the first ground that I think that I saw that could be appealable is the admission of the Madden report. Now there in Madden's testimony himself, on the grounds that the standards were set out in the judgment there about the admissibility of the expert's testimony and the independence of the expert, and there's some legal principles I think in two or three cases that the court cited in there.
Yeah.
And then it seems like the court then went ahead and said that, well, because of what he experienced in patent cases, he was going to use that standard. So you being obviously an expert patent attorney, how does that, is that proper? I mean, what is the court, the
Well,
standard
it was
of
a valiant.
independence of admissibility of the evidence from Madden? That's kind of the
Yeah, it was a valiant attempt from Wright's side to try and discredit Patrick Madden. That's what they were trying to do, and that's what you do in cross-examination. You try and discredit the other side's witness. But the problem with that is, and I think all the allegations that he didn't write the report, it was written for him and he just signed it or whatever they were saying. That's all just nonsense. I mean, the arguments just do not stand up, and the main reason they don't stand up is that Wright's own experts agreed with him. So you've got the Madden report, and you've got I forget what the guy Plack was it?
Plaque, yeah, Dr.
Plack
Plaque.
and another guy, uh, and they had a joint report, and on almost everything that Madden came up with, Plack agreed. So
Mhm.
just
So
that argument that he was his evidence or his testimony on the stand was meant that he was in some way biased.
Right.
Kind of, it doesn't even matter
Now
because
let
Wright
me just
decided
throw
against it.
this little tailspin at you, because if I reading the judgment or reading what Wright said, I believe this is what he's going to put on appeal, and I would love to have your feedback. He's going to say, well, or he could say that, well, there was interference from a bad actor, which there's now come out on another case in the similar, it's under the same court, different judge, by a gentleman by the name of Mr. Edgar Hansen, who's been found, a judgment has been found against him as being a bad actor, and interfering with, with this, with Wright's property. And so I think that's where Wright's going to go with it. And he's going to probably say, well, Mr. Edgar Hansen, maybe he was the one who hired those experts and they went rogue. Or I'm just wondering if there's any way that Wright could bring grounds on appeal for that potential interference with Edgar Hansen.
Oh, he could do, but the question is whether he's even going to bother appealing, because I'm pretty sure he's not even going to appeal. All the signs show that appeal is not going to be filed.
Really?
Yeah.
What do you, and where are you basing that on?
Um, based on all the history being deleted of, let's say, Calvin Ayre's background on his website has now been all reference to Craig Wright being Satoshi, or even Craig Wright at all, has been expunged. All the CoinGeek articles that mention Craig Wright being Satoshi, I think hundreds of them have just gone. If you try
Wow.
looking through CoinGeek now, go back and try and find something that mentions Craig Wright being Satoshi. It's not there.
Wow.
Videos have gone, loads of things. I mean, it's a massive history rewriting process that's gone on in the last week or two. Now, why would anyone do that if they were planning on appealing?
Yeah, it's a good question. I mean, all I
I
was
mean,
going off of was,
to be fair, this is probably all directed by Calvin Ayre, and Calvin Ayre is not Craig Wright. So if Craig Wright was doing it purely by himself, then maybe he's still thinking of appealing. But he certainly doesn't look like he's being supported by Calvin Ayre anymore.
right.
Calvin Ayre is kind of, he's busy washing his hands of this whole thing, and it's looking like, who was the guy that fell out with Lenin? Trotsky, was it? And then got written out of history, airbrushed out of photos. That's what's happening at the moment. So that looks to me like, that it's the end of the line, and also the dropping all the other cases, So that the Kraken and Coinbase, I'm not actually sure if they've been officially dropped, but the tulip trading pineapple hack case was dropped. Hodlernaut's libel case was dropped in the UK and the appeal in Norway.
Hmm.
Um, what else? I'm pretty sure the Kraken and Coinbase passing off cases are either, stayed or dropped or something. I've not heard anything about it, but I would be very surprised if they weren't dropped as well, because they're lower down the hierarchy of plausibility. So I
Wow.
would expect those to be dropped as well. So dropping all the cases, rewriting history, none of that points to an appeal being even contemplated.
Right.
So
Wow. Well, that's definitely interesting. I was just going off of the tweet Wright made immediately after the Wright judgment came out saying he was going to appeal. So
yeah, it
maybe
wasn't written by him though.
no, could have been
And
somebody else.
it didn't say it didn't actually say he was going to appeal. I don't have it in front of me. It was something like, I'm considering whether to appeal,
Hmm.
or I'm contemplating an appeal, or whatever, was that effect. But it didn't say I'm definitely going to appeal this.
Well, there's a certain timeline, so we'll be watching it. What is it, 20 days or something like that, or
That's the
30
thing I'm
days?
a bit unsure about, because in the judgment itself, it doesn't actually. They usually do set a. I'd have to look at other judgments now, but usually they make it clear that there's a 21-day period for applying for permission to appeal, et cetera, et cetera. That isn't in there. It isn't in the judgment. So I'm wondering if it's as from because it's that how this is separated. There's the judgment, which leaves out any consequences, what's the word? Things that will happen as a result of the judgment, injunctions and things, that's going to be decided at a hearing tomorrow. So
Okay, it's tomorrow, not today.
in
So
the High Court tomorrow, there'll be a form of order hearing, and a few people I know will be attending that.
got it.
So we will hear about what's discussed and what's argued at that hearing tomorrow. So that will be about, okay, we've read your judgment. Now, what are the consequences of this? What the judge will be saying, what do you want me to do about it?
Okay,
Uh,
they're gonna hear some
what
sort of
order?
equitable
What
relief.
order do you want me to make?
Yeah.
And Copa will be setting out, what form of order that should take. And I don't know, they'll probably want some sort of injunction on Craig Wright to not say is Satoshi. I don't know how wide that injunction will be, or how wide that the judge will allow it to be.
In a
Don't
civil
know.
case, like this, can a court make equitable relief to turn it into a criminal action from the bench there, or is that totally separate? Like criminal penalties.
Well, the judge does. I don't think in this case that's going to happen. That's not the way this is heading.
Okay.
But what Copa has already said at the barristers have said at the end. I think it was Alexander Gunning that said at the end, they're going to press for this to be referred to the Crown Prosecution Service. So
Okay. They're gonna ask for a
that's
referral.
they will ask the judge to refer it to the CPS because of all the contempt of court, perjury, forgeries, fraud on the court, whatever wording applies to what he's done. But these are criminal things. Perjury is definitely a criminal thing, and I don't know. How many times did he commit perjury? Hundreds, hundreds of times, and there are admitted but proven, according to the judge, 40 times, 40 documents that are forged. Okay, that's fraud in the court. And things were submitted during the trial that were then shown to be forged. The whole nonsense with the emails that were supposedly from Ontier that were forged by Craig. That's even more serious, I would say, because that was during the trial. That was not just, oh, something I made up and submitted before the trial. And all the latex nonsense as well. The trial was delayed for. So that was a huge waste of everyone's time, and it turned out to be completely forged. So there's serious stuff. People have gone to jail for much, much less than that.
So it sounds like tomorrow they're gonna make a ruling on that and determine
That that
not
won't be
necessarily these guilty, but at least if there's gonna be a referral or what's gonna happen.
the yeah the equitable relief
Equitable relief. Yeah.
will be decided tomorrow, but the criminal stuff would have to go to a criminal trial.
Yeah.
So you've got all the documentary evidence and all the judgment itself that will then get passed as a bundle to the CPS, and the CPS will decide whether to press charges. I I'd be very surprised if they didn't. The names that come to mind from the past where people have lied once in a civil trial are Jonathan Aitken, Jeffrey Archer, Chris Huhne. These are all politicians in the UK. Jonathan Aitken lied in a libel trial, saying he was somewhere when he was somewhere else, or his wife was somewhere when he was somewhere else, and it resulted in he committed perjury, one lie. Jeffrey Archer said he wasn't somewhere when he was, or he didn't pay off this prostitute, and he did. Again, libel. They both went to jail. Chris Huhne was a Liberal Democrat MP. He got a speeding ticket. And he was just about, we get points in the UK. So if you get points for a speeding ticket, if you get above 12, you get your license taken away. And if he took this speeding ticket, he would have lost his license. So what did he do? He got his wife to take the ticket. Turned out that that was found out. So getting your wife to take your speeding ticket, perjury, went to jail.
Hmm.
Now, I mean, that's a pretty small lie, but it's serious. So
Yeah.
compare that to the amount of stuff that Craig Wright has done.
Yeah. So it sounds like based upon the three there, there's a pretty small that it could be a likelihood of a referral there. So
I think so. I
let's
think so.
see how this settles out. I know there's a period and the judgment has to settle, and then we'll see what happens. We'll be following it. So, well, can we move over to the other stuff you've got going on right now? The
Yeah,
IP
well,
stuff.
I've got some notes in front of me. One of them says
Yeah,
time coin. I'm supposed to
Timecoin.
mention time coin.
I haven't heard about that Timecoin.
Sorry, that's a joke.
Oh,
Anyone that's
talking
watching
about the
this,
joke with the guy. Yeah, I get it.
anyone that's
Witness.
watching this who's
Yeah.
paying attention to the case. Yeah.
All
Sorry,
right. So
Robert Jenrick. Yeah.
little generate. So, all right. What is the status of? I know you've been. Well, it sounds like I'm hearing rumor that you're working on an IP action or administrative action with nChain or against nChain with Mr. Van Pelt. And I wanted to hear, is that true? And if you could tell us a little bit about what you're doing on that.
Well, I think I mentioned it last time. I've been watching nChain's patent portfolio for the last 2, 3 years. And I got in touch with Arthur and asked whether he'd want to opposition against one that looked to me like a slam dunk, as it were, to put it bluntly. There's a patent that was granted by the EPO, European Patent Office, and it was obvious to me looking at the patent that the attorney dealing with it, I'm not going to name names, the attorney dealing with it made a terrible error, made an amendment that added matter. And the EPO is very hot on added matter. They don't like you adding any subject matter to a patent application that wasn't in the original one as you filed it. But it was a simple switching around of words in a claim that meant that the claim meant something that wasn't what the application originally said.
I see. So an
So
amendment
that added matter.
to the granted patent versus the application.
An amendment that got the application granted.
And that was
So
material, that amendment, in your opinion?
material, well, it was. Well, I don't think we've got the time to go into the details of what the amendment was, but basically it was, the amended claim said it was a method of doing something blockchainy, and then it said a transaction did such and such a thing, and it was in the wrong place. That particular step of the method was in the wrong place. It read in the way that it read. It said one part of the system did something when it couldn't possibly do that. And the examiner, well, first of all, the attorney made the amendment. Then the examiner didn't spot that it was wrong, and the two other examiners on the examining division didn't spot that it was wrong. So already got 4 people that didn't spot this error. And then another attorney at the same firm signed off on it. So you got 5 people that signed off on this, and then it got granted. I looked at it for 5 minutes and went, "That's dead." So, and it was dead because there's an EPO in the European patent law. If you add matter by adding a feature to a claim, and then it gets granted, it's in this inescapable trap because after grant, you can't broaden the scope of a claim. So you can't take anything out of your claim 1 because that would broaden the scope. So if you've added matter and the examiner didn't spot it and it gets granted, then you can't fix it. It's not fixable because you can't take it out and replace it with something else after it's granted. So that was the basis of the opposition. And I saw right at the outset, this was almost 100% certain to win. So this would be a nice bit of PR against nChain. And Arthur went, okay, well, we haven't got the money to pay for it. I'm not gonna dig in my pocket to pay the whatever it was, 900 euros or so opposition fee. That I put in some of my spare time to write the opposition. Took me a couple of hours, I think. So not a very long one. And then we got crowdfunded, and various Bitcoiners threw some money at us, and we paid for it that way. And that was 18 months ago. So it was filed 18 months ago, and then had a couple of back and forth with the European Patents Office. The attorney had a go at trying to argue against it, which was hopeless. And then at the last minute, nChain switched attorneys, which I thought was really unusual. So they switched to a different firm of patent attorneys, and I thought, okay, maybe they're they know what they're doing. They're giving it to someone who's really experienced in oppositions, and they're going to pull something out of their hats, because you never know. You can never be 100% certain. Someone might be able to pull a really crafty trick and manage to rescue it. And then a week later, they decided to revoke the patent themselves.
Oh, so they stipulated and revoked it.
So they just completely gave up. They admitted.
Wow.
They admitted defeat. That's
when was
throwing in the
that?
towel.
How long ago was that?
A couple of weeks ago. Yeah, not long.
So that one's, that's a win, and that one's just, got to
So,
win on that one.
Well, I was sort of looking forward to what had happened is that in oppositions, almost always you get oral proceedings. So you get the right to be heard. Both parties get the right to be heard, and the oral proceedings have been scheduled for 3rd of July. So I suspect what happened when it was switched to these new attorneys is that they had a good look at it and went, we're not going to win here. It's just going to be embarrassing. So the best way out would be throw in the towel and ask for it to be revoked, and that's an end to it. And then you don't get the hearing. Because I was mentioning this on Twitter, and there were the various people saying, yeah, I want to attend, because it was public. It would be a public hearing.
Oh,
so it would have been interesting to have that on show. But
yeah, it would have been. So let me ask you this.
Shame that's not going to happen.
Is there any other actions that you're involved in right now against nChain?
We ended up getting more money than we expected when Arthur did the crowdfunding. So we had enough to do 2 more.
Oh, 2 more. Okay.
So that we've got 2 more in the same family. They're very, very similar inventions, almost exactly the same invention, but they don't have this added matter problem. Instead, they have a problem of not being novel over that book there, which is Mastering Bitcoin by Andreas Antonopoulos from 2014. And these applications was filed in 2016, 2017, I think. So the examiner didn't really look that closely at the book. It was cited during prosecution before it was granted, but I think the examiner was only looking at a very narrow portion of the book, and I pulled out some more bits of the book and made an argument that these patents were not novel over the book, and then again, nChain's attorney didn't put up much of a fight. We don't really have the time to go into detail again, but yeah, those don't look very good for nChain either. And they've got hearings coming up in September.
Okay.
But we've got a bit to go on that. They've got the last chance to. Those have also been switched to another attorney, but the attorney's got until I think towards the end of July to file final written submissions. So we'll see what they manage to pull out. I don't know. That one is, maybe 90% rather than 99%. So there's a chance they might be able to rescue something, but we'll see.
Sounds like those are in the pipeline. So, the last thing I wanted to ask you about is a potential debate over the intellectual property, because
I saw that.
I did speak to Mr. Alizon, Robert Alizon, at nChain. Yeah. He's the chief IP officer, and while he didn't give me a yes or no, but I told him I would at least present it to you, and then if you were open to it, then he would explore getting it approved and potentially discussing, debating. Just he said he would only agree to the IP. He would not debate the Copa case because he's not knowledgeable on it. It wouldn't be if as long as you were open to that, that's what he would agree to. He would at least he would agree. I think he has to get it approved by some PR department, but
Yeah,
uh,
well, I know who he is. He's another European patent attorney, and we have a code of conduct, which basically says we've got to be nice to each other. So I'm not going to say nasty things about him, but he is nChain's patent attorney, and nChain have not been nice to me. So I'm not going to go into the details, but before I would even contemplate that sort of discussion, I'd need an apology from nChain, and they know what it's about.
ah,
Okay.
okay.
But again, I'm not going to go into the details.
Okay. So, well, perhaps I'll, have him on and I can ask him if he would apologize. I don't know. I don't know what the details are, but I'll, let him know. And,
Well, maybe he doesn't know. I'm not going to try and impute that he does know. But there was a character assassination attempt made on me last year,
ah,
um, which was pretty serious. It didn't really go anywhere. But yeah, whoever filed it, and I'm pretty sure nChain was involved, um, not acting in good faith. Definitely not. So I'll leave it at that.
all right. So it sounds like on the condition that you get an apology from nChain, then you would
Or at
consider
least an explanation.
or
Well,
an
if it doesn't
explanation.
apologize, some sort of explanation would be nice. Some sort of maybe an admission as to who actually filed it. But let's see.
Hmm. All
No,
right.
it's
Well,
still a bit of a bugbear. Um I'm not gonna dwell on it too much, but yeah, it bugs me. It bugs me.
Well, the idea is that, a lot of people have questions and doubts about the nChain patents. The nChain patent has a lot of claims that they're valid, of course, made by Dr. Wright. And, you guys are the ones qualified to discuss this. And so that's it would be on total
Well,
opposite points. So it'd be
it,
great.
it's probably it's kind of irrelevant. I mean, the if you pick apart individual patents, you might find some valid, some invalid, but it's all kind of irrelevant. What's the core of the issue really? I was thinking about this earlier. It is we now know, and we can safely say that Craig Wright is a liar and a fraud, and lots of things result from that. There are lots of consequences from that. One of the consequences is that nChain was set up, or whatever it was called at the time, EITC Holdings or Encrypt, and then became nChain. It was set up on the basis of a lie that Craig Wright and Stephen Matthews, who was also in the judgment, said lied on the stand. So Craig Wright and Stephen Matthews acted together with Calvin Ayre's help. I don't know whether Calvin Ayre was in on the lie or not. Let's say he wasn't. But nChain was set up with the business model to commercialize, patent Craig Wright as Satoshi's inventions. And the key being Craig Wright is Satoshi, and therefore he has special knowledge, and therefore let's extract all this knowledge and patent it, and we'll make billions. So at the very core of that is the idea that Craig Wright is Satoshi. Now, Craig Wright is not Satoshi. So the whole of nChain's business model is based on a lie. What does that mean for the patents? It doesn't, just because they're valid doesn't mean they're worth anything. If they're valid, they've got through the system. If they're a Craig Wright invention, I mean, who's going to find any worth in that when they know that Craig Wright is a liar? And all there's also the amusing techno babble that's mentioned many times throughout the judgment. It's what he does. I mean, it's effectively what was, and this is not just me speaking. This is me hearing from people who used to work. I'm not going to name names, but people who worked at nChain. I've been in contact with at least two of the inventors there, no, three of the inventors there, who were named on quite a few of these patent applications. And they basically say that the mode of working through getting these patents in the system was that Craig would come out with all sorts of technobabble, mostly just have a meeting and then come out, speak all these inventions, come out with all this technobabble, and then someone else's job would be to write it down and turn it into a patent application. And the one of the inventors just came out and said to me, yeah, it quickly dawned on me that this was all nonsense. It was all just a fraud.
So it
So,
sounds like your point is that if the person, well, apparently the person who if Wright invented the patents and the court said he was a fraud, then the patents don't have any merit. That's your.
well, it's kind of there were lots of other people involved, and there are many, I don't know, 30 odd people, maybe more, named as inventors on nChain applications, and there are lots that don't have Craig Wright mentioned. They don't have Craig Wright as co-inventor or sole inventor.
So what
And
about those? Do they have?
who knows? Some of those might be worth something. I don't know. You'd have to look at each particular one, but the ones that where they've originated from Craig Wright, I would say, why would they be worth anything when the provenance is so dodgy?
Right. Well, I'm gonna, I think this, you make a valid point. It's probably a question. Well, it's a question in my mind, a lot of people's minds. So is that what happens to the patents? I mean, what happens to everything that he's done? And I think that, the best way to handle this is to put a challenge over to Mr. Alizon there at nChain and his team to decide if they want to respond to this and talk or not.
What
So
what
that's
what happened? What happens to the patents is really just a question of money. Who's going to be willing to keep on, because these things are expensive. To keep the thing going is, you only have to do is look at the number of applications, and I know how much I have to charge for dealing with applications and getting them through the system. And who can afford to keep on spending millions a year just to keep these things alive? Let alone fight hard to get them granted, or fight against anyone that might want to oppose them, or threaten. If you want to threaten someone, that's even more money. So it's who's backing these?
Yeah, that's a question I have. Who's backing all this stuff? Do you have
Yeah.
any idea?
Well, so far it's been Calvin Ayre, hasn't it?
Uh,
Calvin
you
Ayre
know,
has been bankrolling this whole thing. That's not controversial. It's his money that's being used to set up nChain and to get all these patent applications through and fund all the R&D. It's a Calvin Ayre enterprise. So if that plug gets pulled, I think fairly soon we'd start to see some effects on the patent portfolio. I've already seen just this year they've been filed. Obviously the model that they've been using since 2016 when they started filing applications. They've been filing an average of about 70 applications a year. So since 2016, right through to 2023, average of 70 a year, plus or minus, between 60 and 100, thereabouts. Right up until the end of 2023. 2024 so far, they filed 2.
now, is it possible that they may be filing them in secret?
Well, if they've so far, I mean, that's a good question. So far, all their initial priority applications have been filed in the UK. And the UK has an unusual system where a few weeks after an application has been filed, it gets entered on the patents journal. So a journal comes out every 2 or 3 weeks and gives you a list of what applications have been filed. It only gives you the title and the applicant name, and that's it. But and the date of filing. So it doesn't give you any detail about the application itself. Just tells you who's filed it and what it's called. So unless they've started filing in another country to deliberately avoid these initial notifications coming out, then they've only filed 2 so far this year, which is a 90% reduction on their previous rate. They might be first filing in the US. Who knows? There's distinct possibility. But why would they do that? Why would they change strategy? And when they've all been filed in the UK, presumably because they've got UK patent attorneys working on them, or a non-patent attorney and lots of other actual patent attorneys. So there's one non-patent attorney that's been working on nChain's application since 2016, who's a very good friend of Craig Wright, who was mentioned in the court case.
She
maybe
testified?
She did testify. Yeah, I was there on the day as well. Yeah, and my impression is she didn't tell the whole truth, but who knows?
Well, it's just exciting. It's David. I think we got a good challenge out there to hear what's going to happen, and we've heard nothing from Mr. Calvin Ayers. So he seems to have pulled a great Gatsby on us, on everybody.
Oh, well, he's gone on his adventures, hasn't he?
Yeah.
Good. He's off an adventure that he's been long planning.
Yeah, seems
just
like
just happened to coincide with the end of the trial.
I was at the London blockchain conference that he had put on, and he wasn't there. He was nowhere to be found. So if he's on an adventure and he's pulling
That's such a shame.
He's become Mr. Great Gatsby himself now. So he's
I've not read that book. Is that what he does at the end? Does he disappear?
I think that
maybe don't spoil it for me. I'll have to go and read it.
Well, maybe that's a poor. The end of the good book. I don't know about how that would apply. I don't want to make that reference. It's unfair to Mr. Calvin Ayers. So, but it's I guess that appearance of the aloof appearance is that we don't really know where he's at or what's going on at this point. So,
no, I have no idea.
Yeah,
but I do. I have seen that as mentioned before, this history being rewritten. There's stuff going on behind the scenes that we don't know about, but that we can see the signs already that there's some movement going on.
Yeah. Well, somebody's spending over $2 million a month right now on development of something called Teranode. So I don't know who. That's a lot of money. And I actually asked around London about that. I mean, I didn't get an answer. No one really, it's not really clear. So, but somebody's spending that type of money right now.
Why would it cost so much money?
I don't know, and I don't have any proof of, but I mean, just on hearsay right now, but apparently that's the cost that it takes in development of this Teranode, which is the expanded version of the blockchain. So somebody's taking it serious. I don't know who, and
so are you sure that you're not confusing that with the cost of ordinals and runes?
No, it's a expanded version of the blockchain project called Teranode that they're working on, and apparently it's I mean, they did speak about it at the conference quite a bit, and so I'll have a lot of questions, and hopefully I'll be able to reach out to some people and find out more about it, because I mean, that's something that I've heard that is a $2 million a month nut that somebody's paying for. So some very wealthy person, yeah. I don't know
who knows.
Yeah, that's another unknown. So
it better be good for that money.
I know. Yeah, exactly. So I had a feeling that it was nChain. I don't know. I mean, but I don't know.
Well, it's nChain's thing.
It's got to be nChain. That's kind of what I was thinking.
Well, it's what they employed Steve Shadders to develop.
Yeah, exactly. Yeah, I think it's nChain then. So they seem to be moving ahead, full steam ahead. I don't know. It's going to be an interesting next couple of years. I mean, really seems like everything happens at light speed in this industry, like super fast. So I'm going to
be in the patent world, everything happens like a slow motion car crash.
In patent world, probably, yeah. You got to get your thrills from the chill swim, right? Getting in that cold water. That's where you get your thrills.
Yeah, because normally I'm just like Okay, I've got to wait 4 months before anything happens on this one. I
Let me
better
go back in that cold water. That'll do
do
it.
something else in the meantime. Yeah.
Well, David, is there anything else you want to wrap up with before, and where can people find you before we close?
Oh, people know where to find me.
Tufty the cat.
Yeah, yeah. Well, I've been tough to the cat for getting on for nearly 20 years now. He's long outlived his natural 9 lives. I did say before he was a real cat. He was my cat, but he died about 12 years ago.
Nice. Well, say hi to your friends, your clients. Best regards to you and your family there in UK. And
Thank you.
I definitely wish you all the most prosperous times for what you're doing. And hey, and also congratulations and good sportsmanship with the with your call on the case. You were right. You were right. So I gotta say,
Thank you.
hand clasp across the miles for that one.
I,
Um, you know,
well,
it,
and no matter what anyone tries to accuse me of, I did not buy that judge. He's a
you know,
nice guy, but he's not going to be bought. It's
yeah.
all his own work. I had nothing to do with it.
And well, let's see if we could, I'll leave the door open with a potential follow-up conversation as a potential debate if that comes up. Let's see if nChain responds and see if they, what happens. And then maybe if you're satisfied, we could leave the door open for that.
I wouldn't hold out much hope, but yeah, try. By all means, try.
All right. All right.
Okay.
Sounds good. Okay, David, thank you again for coming on. Okay.
Thank you.
All
Thank
right.
you,
We'll,
Gavin.
we'll see you at the top.